Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 193. As I'm sure you've noticed, the pace of these have picked up slightly. And part of my thinking, to be honest, was that I was going to do a little bit of a 12 days of Christmas thing. The first day of Christmas, my employment lawyer brought to me and so on. Anyway, I thought I'd pick on a case I saw the other day that sort of sparked a train of thought because it's one of those issues that you might expect to come up more often than it does. But equally, when the cases do come up, they can be tricky. So I thought, well, why don't I start my 12 days of Christmas right here, although I can't promise, I don't think we've got 12 days left to Christmas, so I don't think there'll be 12 podcasts between now and Christmas. But I thought I'd pick up this case, have a look at it and sort of develop some thinking off that. Oh, and I have another TV series recommendation, but of course you say. Anyway, the case is Fiona George and Linda Cannell and LCA Jobs Limited. So it's a High Court case and it's slander, libel and malicious falsehood claim. And before you start thinking that Nick has clearly got hidden depths if I've been masquerading as an employment lawyer, but really I'm a libel lawyer, clearly that's not the case. But it does cross over into employment law, as the facts will make clear. I should say at the start that this looks like the judgment was given immediately after the end of a 3-hour court hearing, so it's a little hard to follow in places. But it is clear that this is a preliminary issue that's been listed for a decision. It's not clear to me whether it comes after the facts have been determined or whether the facts are still to be determined. But it's a preliminary point that's been taken. So avoiding libel claims of our own, let's assume that the facts are still disputed. So this is it doesn't amount to final determination. Well, the background and the facts identified in the judgment were that the claimant was employed by the second defendant, LCA, for a matter of a few months in 2018. The second defendant is a recruitment agency. It works particularly in the property sector. The first defendant owns the company. The claimant's contract allegedly included a confidentiality clause, but the judgment contains no references to any post-termination restrictive covenants in there. After the claimant ceased to work for the second defendant, she went to work for a company called Fawkes and Rees, doing similar work. It was accepted that she was in touch with employers and the candidates, some of whom she'd been in touch with whilst she was at the second defendant. She asserted she was entitled to do that. But a couple of months after she joined Fawkes, her old employer, LCA, sent an email to Fawkes, which I'm going to read in full because the case really turns on that. It is with great sadness and disappointment that I write to you to inform you that despite making clear to Fiona, the claimant, both verbally and in writing, of her legal obligations under the terms of her employment with LCA, not to solicit business from our clients and candidates, and Fiona's absolute assurances that this is something she would never do, that she has been proactively approaching our clients for new business, as well as contacting clients from LCA. I'm writing to you firstly to ask that this is something you're aware of, and secondly to ask, from one business owner to another, to ensure that post-employment restrictions preventing her from contacting our clients and candidates is respected by you, and ask for your assurances that this will stop immediately. I've worked hard to build a business based on honesty, trust and loyalty. As I'm sure you appreciate, I will do all I can to protect it. I've emailed Fiona today explaining her breach of post-employment obligations and asking her to confirm in writing, within the next 7 days, that she would desist from contacting our clients and candidates. Failure to receive confirmation will result in me taking legal action, which I know will have an impact on her performance. I allowed Fiona over 2 months off work during her employment with LCA as she was unable to fulfil her duties at a satisfactory level whilst dealing with a personal court case. So, claimant's response was to instigate this legal claim against her former employer and the owner of the company. The hearing was a preliminary issue, and it was to decide what the meaning of the words in that email was, for the purpose of libel, and whether that meaning defamed the claimant. The judge said that the initial approach, which doesn't seem to be in dispute between the parties, was to put himself in the position of an ordinary, reasonable, fair-minded reader of the email, having the characteristics of someone to whom that email was addressed. The judge pointed out that this email was going from one employer to another, both with experience in recruitment of employees, and as such, that would affect the interpretation, the approach and the interpretation the recipient of the email would take to understanding what was in the email. The judge decided the words meant that the claimant, acting in breach of her restrictions in her contract of employment with the second defendant, and contrary to express assurances that she would never do this, did disloyally and contrary to her word, approach the second defendant's clients to get business from them, and also contacted the second defendant's job applicants. As the judge put it, there were two separate threads to the email. The first, that she was acting in breach of her contract, and the second, that she was acting disloyally. Furthermore, the judge said that this definitely crossed the line for the level of seriousness in terms of the impact on the employee to be defamatory. Given an allegation of this type levelled against them in this form, the judge said that the employee would, quote, be a form of damaged product in the hands of the new employer, unquote. As he put it, any new employer might wonder what was going to happen to any restrictive covenants that they might have imposed on the employee when the employee in turn came to leave them. But also the new employer would become a headache for the new employer. There are going to be issues in client contacts and client loyalties. He was, quote, readily persuaded, unquote. The threshold of seriousness was crossed in this case, so he ruled on both points in favour of the claimant. On a side note, and highlighting the difficulties of giving an immediate judgment, which is then transcribed verbatim, I note that the written judgment refers in a couple of places to what the judge says is, quote, gonna, unquote, happen, rather than what is going to happen. Given my ongoing campaign to stop my younger son using this horrible word when he writes, on the rare occasions, emails or texts to me, I'm sure that any corrected form of the judgment will indulge in some subtle corrections. As I say, I don't know whether this quite fits into the overall case, but equally, there was no mention of the level of damages that might be awarded if the facts are found for the claimant. But the case did get me thinking. There's no mention of any legal action being started by LCA Jobs Limited, and so presumably the second defendant took the view that writing a letter to the new employer was as good a way of restricting the claimant's activities as starting legal action, if indeed it had the covenants to start legal action. But here, since the defamatory communications were only published, as far as we can tell from the judgment, simply to the new employer, I imagine the level of damages will be limited, reflecting the limited nature of the publication. But letters before action, these circumstances, do operate by setting out the basis for the old employer's concerns about the employee's actions, and potentially the new employer's actions too. Obviously, where possible, you'll be referring directly to terms of employment and incontrovertible specific factual instances. But to the extent that the old employer's belief of what is going on is wrong, then you'll be publishing something to the new employer, if you're writing to the new employer, which could be defamatory about the former employee on the part of your client. Clearly, if you're writing directly to the individual concerned and no one else, that's not the issue. But often, indeed usually, lawyers will suggest writing to the new employer as well to try and rein in the offending employee's alleged misbehaviour. Defamation claims come up very rarely, and I've seen them threatened on a few occasions, but no more than that, because I suspect because the level of defamation damages probably makes the grief of the litigation not worthwhile. After all, it's far more important if you are the new employee and have done nothing wrong, but the old employer misrepresents the truth to your new employer, that your new employer believes you immediately, rather than some months later a court believes you. But it set me thinking about the other circumstances in which employers are writing about employees or ex-employees. That, of course, is references. Because here, in a way, if you look at it, the old employer was providing an unsolicited evaluation of the employee to the new employer. When I started in employment law, references were very different from the way they usually work today. Employers would often give quite a lengthy reference, and the trick was to try and work out which particular quality or virtue had not been mentioned in the reference, and therefore deduce if the reference was really hinting at something else under cover of a relatively positive statement. Reminds me of a marvellous Alex cartoon, which I may have mentioned on the podcast before. Alex and Clive are reading a statement that's been put out by the head of HR about a departing employee. On the face of it, the statement sounds relatively positive. Alex says that there is no mention of the individual's integrity and hard work. Clive then wonders whether Alex is reading too much into the statement, and Alex responds that he's merely pointing to the footnotes. I had a similar experience many years ago when I was acting on an exit of an individual who'd fallen out with his employer. On his behalf, we laboriously negotiated a full and pretty positive agreed reference to be given in response to any request from a future employer. The HR director then took me to one side and said, since I was clearly at the start of my career, he wanted to pass on some friendly words of advice. He explained he would follow the letter of the reference precisely, but he would read the reference out in a very artificial voice with lots of artificial gaps in the statement he was reading, making it clear it was a pre-agreed statement. And he said any new employer will then draw its own conclusions. Hey ho, we live and learn. Well, the reason why the approach to references changed was the Spring and Guardian case decided employers owed a duty not to make any negligent misstatements in a reference, and that this duty was owed both to the recipient of the reference, which is no particular surprise, but also to the subject of the reference. Although it may have been possible to sue in defamation in connection with giving a poor reference, there were question marks about whether or not an employer could argue that a reference given to a new employer in good faith, even if incorrect, will be covered by qualified privilege, making it harder for the employee to sue. So the opportunity to sue for negligent misstatement, inevitably, and contrary to what the House of Lords thought at the time, put a damper on many references being given. Of course, references are still given, and they're often given in a personal capacity, or headhunters will cull information from a variety of sources, including informal conversations with individuals about a particular candidate. The basic standard is that the employer is expected to meet in giving any information in the form of reference is it must be true, accurate and fair and doesn't give a misleading impression. Well, what happens if the old employer refuses to provide a reference at all? Well, the case of Lawton and BOC Transshield decided there was no obligation generally to provide a reference. Logically, therefore, an employer cannot complain if the employer gives a basic reference only, rather than a more nuanced or full one. I am, of course, talking outside of any regulated area where there are often obligations to answer particular questions or provide particular information. In theory, it would be possible for a former employee to assert that a refusal to provide a reference for that employee when the employer generally provided references might be based on unlawful discrimination or post-employment victimisation. If an employer is planning on refusing any reference, and I think it does need to have pretty clear grounds to do so, either on the basis that it never gives a reference, which I think would be a policy I've never come across yet, or that there are particular and lawful reasons. Years back, I remember advising on one reference where a reference request arrived for a former employee, let's say called Joanna Smith, and the problem was that Joanna Smith had been John Smith while they were working for our client, and my client didn't want to reveal that inadvertently in giving the reference. So they provided a very carefully drafted reference to protect Joanna's privacy. What about a situation where the employer is willing to give a reference but feels it needs to say something adverse because it perceives a duty to the new employer not to make the reference misleading by omission? Now, a reference can certainly be misleading by omission, so that's not an unreasonable worry, although, as I say, I've not yet been involved in any cases where the new employer has asserted that against the old employer. Additionally, if the old employer disclaims any responsibility for the reference in the communication to the new employer, it's much harder for the new employer to argue there is sufficient duty of care on which to base a claim. So I suspect it's relatively rare. But sometimes, and maybe less creditably, if the old employer wants to make the new employer aware of things about their new recruit, they do this under cover of a duty to make sure that the reference is accurate and not misleading by omission. What can the employee do about it? Well, there have been a number of cases, and broadly speaking, provided the employer makes clear that the nature of the adverse event or comment and the ex-employee's position on it, then the employer is likely to be on the right side of the line, assuming that the adverse material is relevant rather than immaterial or irrelevant matters being put into a reference. If it's relevant, then you're also likely to be processing data lawfully when providing the reference, although this may be harder to demonstrate if you're processing sensitive personal data and including information about health, days absences, although in my experience most employers refuse to provide that sort of detail. Going back to the email that I read out at the start of the podcast, you'll have noted, I think, the entirely gratuitous reference to a personal court case involving that employee. And although it doesn't feature in the judgment, I can't imagine that sort of gratuitous adverse comment played terribly well in front of the judge. However, of course, an employee who loses a job from the new employer as a result of an adverse reference or has the job pulled from them may well come looking for vengeance. The courts have accepted that if an employer makes a job offer subject to satisfactory references, then it's for the employer to evaluate that. I mean, I always tend to make that point explicit if I'm putting together any offer, that it's up to the employer to evaluate whether the references are satisfactory. But generally, the courts so far have been pretty hands-off. So the employee probably needs to look at the old employer and make use of a DSAR against both employers to try and find out what has been said. The old employer would probably be liable if the reference was a negligent misstatement or indeed defamatory for the consequences of the new employer pulling out of the job offer. Here, of course, the new employer, if it is pulling the job offer or releasing the employee if they'd already started, will have an incentive to state that the references were not satisfactory. So in this way, the employee may get to what was said and to see whether an adverse comment is either negligent or discriminatory or post-employment victimisation. A long point made brief then is that if you are an employer giving an adverse reference, you need to be giving it in a form that you are comfortable saying directly to the employee concerned or standing by it if the employee then challenges it. And the same would largely go to informal references as well, although there, of course, it may be much more difficult to prove precisely who said what. The other circumstances in which we see references playing a major part are in settlement agreements. There, of course, the temptation is sometimes to try and agree something that is unduly favourable as the price of getting a deal over the line. It is certainly the case that references given in settlement agreements are sometimes wordier and more extensive than the basic, knit work for us from X date to Y date in job title, whatever. I've said on a number of occasions in settlement negotiations, I've never lost a settlement yet that was otherwise agreed over the wording of a reference. So there's usually ways through this. But of course, you cannot agree to give an unduly favourable reference just because it's in a settlement agreement. Equally, it's extremely important that any obligation to give a reference is conditional on the application for that reference going to the right person, and so that the obligation is, as I say, conditional. I had a case a few years ago where I was acting for a company which fell out with its HR director. She raised claims of discrimination, although it never went to actual litigation. We did a deal with her on behalf of our client. She left. She went to a competitor. The director of that competitor told his secretary to take up references, but his secretary told him, there's no need to do that, because I'm best mates with one of the secretaries at the old employer. She rang that secretary, and the secretary of the old employer told her the HR director had been sacked for alleging discrimination. At that point, the new employer pulled the job offer. Can anyone see what's wrong with this picture? The new employer, of course, was dead in the water on the issue of unlawful victimisation. We argued strongly that because our client's obligation to give a reference was limited to a reference request made to our managing director, that we were not liable for what one of our secretaries had said. Frankly, I think that might have been a little bit difficult to sustain, although clearly we were in a much better position because we had got the protection that the agreed reference, which of course made no reference to the materially incorrect fact that she'd been sacked for alleging discrimination, the agreed reference would have been perfectly acceptable for her. Anyway, I think it would have been difficult to sustain that we had a complete get-out-of-jail-free card because they'd wronged the secretary. But I do think we'd have been rather better off on one of our alternative arguments, was that no one should be putting their trust in an informal conversation of that nature. And so we might have escaped liability on the grounds that we could not be expected to monitor what all of our staff said. And she was not authorised to give references on behalf of the company, so we were not vicariously liable for her. Anyway, the new employer settled, we were covered by the settlement, and so we escaped unscathed, but it was quite a lesson. So there we are. References and some thoughts on references. I hope that was helpful. And we'll see what the next podcast brings, number 194. Oh, I promised a TV review, didn't I? If anyone hasn't seen it yet, Tim Minchin, Upright. It's fabulous. It's on Netflix, I think. No, Amazon Prime. It's funny. It's very moving in parts. 6 episodes, half an hour each or so. Really well acted, really well scripted. Give it a go. Upright. So there we go. We'll have cultural references to the end, I promise. Anyway, that concludes the podcast. Thanks everyone for listening. As always, I hope everyone stays safe and out of harm's way. And as always, I can confirm that none of our esteemed government's Brexit negotiating team were harmed in the making of this podcast. Thanks very much indeed. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.